Good afternoon, everyone, and welcome to the webinar, A Broader Sense of Justice, Respecting Victim Autonomy while Pursuing Offender Accountability in Sexual and Domestic Violence Cases. Today's program is presented by Equitas and presented by John Kurland and Jen Dolly. My name is C. Ross, and I'm an Administrative Associate at Equitas, and I'll be moderating today's webinar. If you have a question during the presentation, please enter it in the question and answer box. We will answer questions periodically throughout the webinar. You are also welcome to contact us directly at any time following today's presentation, and we will send you contact information during our follow-up. Equitas's mission is to improve the quality of justice in sexual violence, intimate partner violence, stalking, and human trafficking cases by developing, evaluating, and refining prosecution practices that can increase victim safety and offender accountability. As a national training and technical assistance provider, Equitas develops resources, conducts trainings, and offers 24/7 consultations for prosecutors and allied professionals. For more information on Equitas, please visit our website at equitasresource.org. You can also follow Equitas on Twitter, Facebook, Instagram, and LinkedIn. The link to each is available on our website. Today's webinar is supported by the U.S. Department of Justice, Office of Violence Against Women. The information presented in this webinar does not necessarily reflect the views of the Office of Violence Against Women. Presenting our webinar today are John Kurland and Jen Dolly, and I will now turn it over to John and Jen.
C, thank you so much for that introduction. Thank you everyone for joining us today for this presentation. We're really excited to have you, and Jen and I are super psyched to discuss this important topic. But just to orient you as to who we are, we want to give you a brief intro as to each of us. My name's John Kurland. I work as an attorney advisor with Equitas. I've been with Equitas for just over 5 years. Prior to joining Equitas, I worked as a prosecutor in Berks County, Pennsylvania, which is in southeastern Pennsylvania, and known primarily by the city of Reading. When I worked as a prosecutor in Berks County, I finished off as a chief deputy district attorney. And my responsibility throughout my career was lots of different cases, but my primary focus was on the prosecution and eventually supervision of sexual violence cases, child abuse cases, intimate partner violence, stalking, and some homicide matters as well. It was a wonderful career. It's something I sort of still identify myself with, which is what makes Equitas a great gig, because I get to see all these other professionals from other jurisdictions and see how folks are working to help their communities and victims across this country and internationally too. So with that intro, I'm going to hand things off to my incredibly intelligent colleague, Jen Dolly.
Incredibly intelligent, setting the bar high. Hi, everybody. My name is Jen Dolly, and I am also an attorney advisor here at Equitas. I have been with Equitas for about 1.5 years, and prior to that, I was a prosecutor in Manhattan, in New York City for over 11 years, where I worked on all different types of crimes, but really focused most of my career on crimes of sexual violence, domestic violence, and human trafficking. And I helped to co-found our human trafficking response unit at the Manhattan DA's office, and was its deputy chief, and so supervised human trafficking cases and worked on my own. Did a bunch of wiretapping cases and really kind of learned from a lot of trial and error and mistakes we made, and how to handle those cases that were relatively new at the time. So looking forward to having this conversation today.
Right. Thank you, Jen. So one last bit of housekeeping that we have to address is a fair use notice. Of course, a lot of the content that we have in this presentation, it's resting on a foundation built by others before us. And we're so grateful for that work that we can rely on to help improve our practice and hopefully have a great discussion and conversation today. But of course, the one caveat we want to give is the content and material we're using today, it's used for educational purposes. And so that's why we're giving our fair use notice at this point. So with that bit of housekeeping, let's jump right into the subject of today's presentation. And that is about achieving a broader sense of justice. And Jen and I and C, we were talking as before we filed in, it's like, gee, this title for this presentation, it was a real challenge. And really the title we landed on was probably broader than what was necessary or to understand what we're doing. But Ultimately, what we're trying to do in this presentation is talk about those cases where victims and witnesses aren't able to participate, particularly in domestic violence and sexual violence cases. And we want to talk about ways that we can hopefully minimize that the lack of participation, but also understand some of these barriers for participation. We also want to talk about achieving a broader sense of justice about the idea of trying to avoid the use of extra level measures like material witness warrants or petitions or bench warrants, and taking a deep dive into how counterproductive those methods can be. In those rare cases, those essentially career exception type cases where extra level measures might be necessary for victim participation, we want to talk about how to weigh that, how to weigh the trade-offs between victim safety, public safety, as well as respecting victim autonomy, and sort of think about, gee, when we're making these decisions, that we're doing so in a considered way. And in those rare circumstances where we are going to be talking about maybe some extra level measures are necessary to get justice, we can't find any other method. We want to talk about ways that we can mitigate the impact on victims and still do our job as prosecutors in seeking to obtain justice for victims overall. So it's really 4 areas we're going to be dividing this into, 4 buckets. The first bucket is going to be identifying the barriers to victim participation, why victims drop off, why there's victim participation, trying to understand that. Once we understand some of those reasons, talk about some strategies to minimize that victim drop off, talk about ways we can support victim participation. When we aren't able to sufficiently support victims to a level that they can participate, we want to talk about essentially the trade-offs between holding offenders accountable, but also respecting victims' autonomy and self-determination, and how we weigh those trade-offs and balance them as best we can in an imperfect world. And lastly, we're going to be talking about, in those rare instances when we do pursue those extra level measures, about how we can mitigate the harm of those extra level measures on victims in our case. So if we were doing this live, I'm sure Jen and I would be having a pretty lively exchange and making it up as we go along. Experience has taught us with the nature of webinar presentations. We really are sort of just dividing it up between ourselves. I'll take a segment, hand it off to Jen, she'll take a segment. But I wouldn't be surprised if we decide to interrupt one another or jump in with another point with something we want to make. And I want to urge all of you too. And while there is some content we want to deliver, please don't hesitate to bring up points or issues either in the chat box or chat window or through the Q&A. And definitely, if you disagree with something that Jen or I say, speak up. And heck, if we have the technical ability to do so, we can even unmute your mic and have a conversation with it. So with that said, let's dive in. So first area we really want to explore is, why don't victims want my help? And folks and prosecutors who've worked domestic violence cases, sexual violence cases, and human trafficking cases recognize this all too well. You're dedicating yourself to a case. You're alarmed and shocked by the things the offender is accused of doing, what the police report's saying, what the photos depict, and you really want to get justice. You really want to hold this offender accountable, and the victim drops off. You can't find the victims. And sometimes we're left as prosecutors with the idea, in my experience, it would be almost self-centered on my part. Why doesn't this victim want my help? I would always be casting it or viewing it as, why is this happening to me? Why is the victim preventing me from doing good? And I really wouldn't sort of flip that analysis as to what kept the victim from doing it. And so that's really what we want to do today, is identify those barriers and challenges for victims in participation. But if I may, let me start with something interactive, if I can, or mildly interactive. We're not going to throw you right into it. We're not asking you to defend a dissertation. But just for the folks that are here, if you could share in the chat window, what are indicators you see in your case that a victim isn't going to want to testify, that a victim isn't going to be participating in a prosecution? When do you get that indicator, or when do your antenna go up that that's going to start happening? If you could sort of share, if you could share your experiences in the chat window about indicators or signs you see that victims aren't going to be participate.
Yep.
So we've got one classic, not taking or returning calls. Slow or fails to respond to our office's communications about progress of case. These are common. Survivor has more contact with defense counsel than my office. That's a pretty good sign. Not showing up for court hearings. Express previous frustrations with the system. They're skeptical. Changing story, recanting, minimizations probably too. Phone number, no, I assume the pound sign is for phone number no longer working. I'm old enough to know that's not hashtag. That actually means number.
I don't think people use hashtags anymore.
Well, yeah, so I missed the fad entirely. When I file a case, I may already assume they don't. Defendant's attorney tells me they're back together, has expressed wanting it to be over, wanting to move away, relocation. Non-citizens with unstable immigration status. So
There's a survivor who has an attorney who is blocking your ability to communicate with the survivor directly. That's
oh,
another
did
one.
I miss that one?
Yeah,
I'm
I'm double. I'm following along.
Police couldn't get a hold of them for follow-up interviews
Mm-hmm.
and fear.
Mm-hmm.
So these are all good. Some of these are really explicit, and some of them are a little bit more implicit about what's going to happen. And experience tells you that the victim isn't going to participate. But you've really captured all these reasons, indicators that victims aren't going to testify. Sometimes it's really upfront and blunt. I don't want to testify. I want these charges dropped. I don't want you to pursue this. They tell you directly. Of course, a lot of times it's almost like you sometimes almost feel like you're ghosted. You can't find them. You can't reach them. You make appointments with them and those appointments are missed. You find out about some post-crime contact with the offender, continuing contact with the offender. The recantation or minimization is probably a good sign they want the case to go away. And sometimes, and that's why I love the expression about the skepticism from the system.
Mm-hmm.
They're skeptical about what's going to happen. You sometimes know from the history from prior cases. Maybe that history is showing in other cases that the victim dropped off or the victim didn't want to testify or couldn't be found. Maybe those prior cases are telling you that maybe the victim was treated kind of shabbily by the system or adversarial. So the victim's in a position where they're not trusting us or where it's going to be really challenging for us to get to that victim's trust.
Mm-hmm.
But these are all sorts of indicators. And the reason why I indicate is why we're talking about these indicators is because one of the things we want to do in talking about these barriers to participation, we don't just want to talk about, gee, this is what we do when victims don't participate. And although we are going to address some options and strategies, but ideally, we want to figure out ways we don't have to cross that road. What are some ways we can even minimize this lack of participation? But the first step towards that is understanding what these barriers to participation are. So here, and this is by no means exhaustive, but just an opportunity to maybe identify some of these barriers to participation. And this is something personally for me, it took me a while to learn because as a young prosecutor, when a victim dropped off, I always took it as an affront to myself, or I took it personally, or like the victim was doing it to sometimes spite me. And I really had sort of an immature, a non-empathetic view. But when we look at it from a victim-centered perspective and understand these barriers that victims have to participate, ultimately, we shouldn't be so surprised by the lack of participation, but we should be immensely grateful for victims that do participate, especially in these kinds of cases where there's an intimate or some kind of pre-existing relationship with the offender, like intimate partner violence or trafficking or sexual violence cases. Because some of these barriers of participation, for most victims, it's not going to be just one of these factors, but it's going to be sort of a potpourri of these factors all mixed together, impacting a victim once in a variety of ways. But one of these barriers of participation might be the re-traumatization and the idea of coming into the system that essentially when they come in, they're going to have to recount or in some ways relive this traumatic experience that happened to them, either the physical assault, the sexual assault. They're going to have to go through it again. We're going to be asking them through our questions, through testimony for that examination to relive what happened to them. And for some people, that makes it a lot more challenging and a lot more painful to process. And there can be a lot of fear about that too, which is going to be one barrier. But that's not the only barrier. And let me hand off to Jen here so we can sort of trade off on these barriers.
Yeah, and another one that you all mentioned a lot was this kind of inherent distrust of the criminal justice system, right? And I think when we work within the criminal justice system for our careers, I like John still still say us when I talk about the DA's office I worked at, and I haven't worked there in years. So I think when we work within that system, we see how it can be really, helpful and can really kind of, can achieve justice for victims, right? But I think that then we end up being a little bit myopic in our view and not understanding that, first of all, it's just one part of what an individual is dealing with, right? So, and it's just one kind of branch of everything that's going on in their life. And when someone has had some of that history with the criminal justice system that's not positive, whether that's interaction with someone in law enforcement, another prosecutor, a defense attorney, a judge, there's someone in probation, whether individuals maybe been arrested themselves, and especially in underserved communities that don't have really great interactions with law enforcement, a lot of times it really can kind of be a chilling effect. And we have to understand that may have happened. And again, be humble and understand that the criminal justice system isn't the answer for everybody all the time. And really you are kind of starting maybe, behind the 8 ball and really trying to kind of build that trust again. And then, kind of follow up is that time lost to court and investigations, right? So it's our job. So we're there and that's what we're doing. But, really, I think something that I wish I'd thought about more is the kind of real life consequences and that time off of work or time off of school or having to find someone to help take care of children. So all of that, we really have to recognize is barriers to someone really feeling like they can be able to participate in a system when they are also re-traumatized and dealing with all of this that's going on.
And often I think our court system to satisfy the value of thoroughness, the trade-off has to be for efficiency. Yeah. And that trade-off with efficiency is going to impact victims who sit around and wait around. Yeah. But the other factor too is, and it sort of relates to this re-traumatization, because not only are we asking them to relive assault, but we're asking to relive the thing that brought them into the courtroom or brought them into the system. But we're asking them to be almost second guessed about how they handled it and how they processed. And especially victims who might have experience with the system or maybe even are having continuing contact with the offender. That idea of participating, there's going to be maybe a lot of embarrassment or self-blame. Maybe our victim's going to be second guessed for staying in the relationship with the perpetrator, with the offender, not leaving. Maybe the victim was using drugs or using alcohol. Maybe our victim was a sex worker, and that's going to be put in the spotlight because on some level, to be victimized, the offender identified a vulnerability that was real or a vulnerability that the offender perceived, something that the offender believed, like this victim isn't going to be trusted. This is a victim, I can get away with doing this. And a victim's going to have to disclose or on some level expose that vulnerability the offender identified or believed in, and really just have a lot of their private life exposed, as well as, hey, at the end of the day, no matter how much we tell them it's not that complicated, a lot of victims believe, like, if this doesn't end up positively, if this doesn't end up in a conviction, I'm not going to be believed. And there's a fear of that kind of rejection that's pervasive.
Right, absolutely. Just that getting in front of, being in a courtroom and having to tell 12 complete strangers, let alone who else might be in that courtroom, what happened to you is really daunting. And so it really is, the onus is on us as prosecutors and those of us in the criminal justice system to really kind of reframe it as, what did the offender do? They picked this person because of a vulnerability, as opposed to that person's at fault because of that vulnerability, right? So kind of always be thinking of that in the back of our minds as we do this. Isolation is another big one, right? So feeling alone and unsupported. and really kind of experiencing that continued impact of trauma, right? I think we're all becoming a lot more educated in the effects of trauma, and continuing effects of trauma, right? And the way that that can affect one's ability to kind of recollect an event and to move on and be able to kind of go forward afterwards. And then, having to relive and retell this story is just re-traumatizing, and again, increasing that isolation. If they don't have people that, are believing them outside of the justice system and kind of feeling, feeling an impact from those associated with the defendant or with the offender, right? So being ostracized and all of that is really something to take into account.
So another factor, of course, is going to be witness intimidation or harassment. This is really something, well, all these factors are outside the victim's control, but this is something where a victim's targeted. And witness intimidation and harassment, and we have entire content and archived webinars taking a deeper dive into this, which we're not going to be doing in this presentation. But look, a lot of domestic violence cases, sexual violence cases, and human trafficking, unlike other cases, there's some kind of pre-existing relationship, if not intimate relationship, between our offender and the victim. What this means is you're going to have an offender who has more access, more of a relationship with the victim. And what that can translate into is that even when we start our cases and the prosecutions begin, that offender and that offender's network, friends, family, what have you, are going to have access to the victim. They're going to have more opportunities to pressure the victim, either explicitly or implicitly, about the damages that are going to be occurring or the risks that can happen from participating in a prosecution. And maybe that pressure can be the ostracizing them, like we were talking about with isolation, or maybe implicit, like, wow, if this guy goes away, look what's going to happen to his reputation. Look what's going to happen to their ability to earn income for family or for friends. Look what's going to be doing. It's easier for it to go away, and everyone's going to blame you, not him, for doing this. So that sort of intimidation. Sometimes the intimidation might be more explicit. If you do this, you'll get hurt, or these bad things will happen to you, rather than just guilting. But of course, sometimes those intimidations can sort of play on very real feelings and affection or sympathy that victims might have for an offender. This is especially prevalent with intimate partner dynamics. And these sort of feelings of affection or sympathy or concerns from the offender, sometimes that's going to be the product of a cycle of grooming or power and control cycle that the offender had exerted over the victim over a history or course of a relationship. But it can also be combined with genuine feelings of affections. Family dynamics and family affection, I mean, just in our own lives, which are hopefully all healthy, they can be pretty complicated and pretty tight. And that isn't necessarily less so for the victims we're working with, even though the person in their family circle or their domestic circle is someone they're close to. There's still love, there's still affection, they're still not wanting something bad to happen. And of course, this barrier isn't happening in isolation with these other barriers we've been talking about. In addition to the very real collateral consequences of, hey, wow, what's going to happen if I lose my intimate partner to this prosecution? What's going to happen to their ability to support me, their financial support, how I need them for childcare, housing issues, emotional support on some level that I get from them, especially if they've been isolated from their own network through a DV cycle of power and control. All these collateral consequences that are going to be happening because of participation in a prosecution. So we talk about these barriers of participation as a way to sort of understand why victims drop off. And hopefully, so on some level, we can start thinking of, gee, rather than use extra level measures or think about ways we can coerce victims to participate, think about these barriers and then think about methods or strategies we can use to hopefully minimize these barriers or mitigate these barriers on some level to better facilitate participation. So let me take an opportunity quick, and I'm going to hand off a section to Jen here, but I do want to make a note on language. And you note I've been using the word participate. I haven't been talking about victims who cooperate or uncooperative, and that's intentional. And I'm noting it here, not because I want to be pedantic or like correcting everyone if you use the word cooperate, because that's not really it. But let's look at the dictionary definitions right here. Uncooperative. This is Merriam-Webster definition. The definition is marked by an unwillingness or inability to work with others. Participate in relevant part is talking about to take part, to have a part, or share in something. Well, there's a reason I always think participation or not participating is a better way to describe victims testifying or being a party or participating in a prosecution, because participating more talks about something the victim has ability to. When we talk about victims not cooperating, why I really don't like using that terminology is because it really doesn't quite fit. Because we talk about uncooperative, like there's something volitional victims are doing. They're deciding, hey, I'm not going to testify. I'm not going to work in this case. I'm not going to help the prosecution. But that willingness or putting that sort of onus on the victim about the case really doesn't fit, because all those barriers are ultimately something caused by the offender, either the offender's original offense or the offender's either grooming or cycle of power or control. All these barriers to participation that we recanted, and probably there's a lot more that Jen and I didn't talk, there's something that traced back to the victim. So just as a matter of terminology, victims not testifying, that isn't really born necessarily out of something of free will. It's because of circumstances that are created by an offender. And so that's why in terms of language, we're going to use participating or not participating rather than cooperative or not cooperative. So with that said, I'm sure you're all anxious to hopefully this has some resonance, what we said about these barriers to participation. A logical next question is, what the heck can we do about it? And Jen Dolly's going to field that.
Yeah, so what are we going to do about this, especially knowing that this is, there's a lot going on behind the scenes that we're not seeing, right? And so how can we work to minimize these barriers of participation? Because I think we've all, if you work on these cases in whatever capacity, you have seen cases where a victim is able to participate in the system and is able to go through the system and even maybe testify at trial, and can be something that's really empowering and can have really positive effects too. So how do we kind of make that, give someone the support to be able to do that, right? So I think, we started with this because really building that relationship with the victim, everything that comes after it is really based on that, right? So this is really key to the job of a trauma-informed prosecutor, is you really are focusing on that relationship with the victim. And I think sometimes we can get a little bit, myopic in our view of, I'm worried, I need to get the facts. I need to know what I can charge. I need to know whether I'm charging this or not charging. And you get kind of a little bit lost in kind of those other parts of the job as a prosecutor. But really that relationship is key. And it's really where you're able to kind of build off of and really make major steps into kind of minimizing all of these barriers. And so, educating the victim about the system, what the charges might be, and the case. And I think we used to avoid secret ingredients in here in terms of kind of just saying that you want to be really transparent as much as you can, have really, really, really realistic conversations with the victims about these cases, and don't assume that someone knows what the process might be like, and keep someone informed about the process, unless of course they ask you not to contact them. But keeping someone informed of what's happening is really, really important, and kind of goes a long way to saying, hey, I'm also concerned about you as a person, right? I'm not just concerned about this case. I want you to know what's happening so that you can be kind of a part of this process and an informed part of this process. Listen to the victim and learn about them, right? They're the expert in their situation. They're the expert in what's going on with them. And this is not just listen to them about the facts of what has happened to them, but listen to them about, safety planning and about what their concerns are and what their needs are. We say anticipate some of those concerns and fears, and we can do that. But also it's really, really important to talk to each person and to understand that they're in the best position to tell you what their needs and their wants are, what justice looks like for them. Sometimes we're able to really kind of put that at the forefront, and other times we're not. But knowing what that is and having those conversations and those honest conversations with someone goes a real long way to kind of assuaging some, or I hate that word, to kind of minimizing a lot of those fears that they may have, and things that may be going on in the back of their mind. They're concerned about, how often do I have to come to court? Do I need to come to court next time? Will so-and-so be there? What are the practical kind of concerns? So thinking about that, and then adapt your practices to that victim as much as you can, right? And again, be really honest and don't make promises you can't keep. I think, as a younger prosecutor, I was always trying to be like, okay, I'm going to do this and we're going to do this. And you were really eager, but a lot of it is out of your control as a prosecutor. And it's really important to kind of have those conversations about what you can and what you can't control, and what you can and can't do, right? So that you're not setting it up to disappoint that person or to go back on a promise, because then again, you're getting to that trust and you're breaking that trust again.
Like with adapting practices, Jen, I think a good example of that is be conscious of their life. Like, don't set a meeting for them at 3 o'clock when they have to pick up the kids at 3:30. Especially when they might be single parenting, and then wonder, gee, how come they didn't seem to be paying attention or focus?
Right. And think about it. And too, like, think about, this is something I think we always kind of, as prosecutors, we're like, oh, there's going to be a continuance in the case or for X, Y, and Z reason. And it's like, well, but that might, think about what the effect that's going to have on the victim, right? And so, things of that nature. Or can you meet the victim somewhere else? Did they have to come to your office? Can you make it easier for them to get to you? Is there somewhere else you can meet with them? So all of that.
Oh, sorry. There we go.
I think we missed one slide. Sorry.
I think this was the next one.
All right. So we kind of we're talking about advocates, right? And the types of advocacy that there are, right? So you may be dealing with advocates that are community-based. So advocates that are part of community. They're not employed by the criminal justice system, right? There we go. Am I out of order? So they're not employed or, by your office, or I know a lot of offices have social workers that are employed. We were very lucky to have one that was actually devoted to our human trafficking unit. And there's a lot of positives about that. If it's a system-based advocate, right? So if it's someone within your office, someone within law enforcement, and there are a lot of pros to that, but there are also, you have to think about that disclosure, right? There's not the privilege with that. Community-based advocacy. So someone that you are referring that victim out to get services from an outside agency. And typically, with a few exceptions, they have legally privileged communications with the victim. So that can be really helpful. And really what's really important about advocates, whether they are system-based or community-based, is they are really focused on that victim and that survivor, right? That's their focus, is the well-being. And while as prosecutors, we can also have that focus, we are also, first of all, we're not trained in social work and in that, but also we're also dealing with this, what's happening with the case and what's happening with that. So there's all sorts of benefits of having an advocate involved in your case. And I know I was really, really grateful to have ours, because they really were a check on me as well, right? A check on me to be like, this person needs a break, this person. And it's so as well intentioned as you can be, it's really important to have that advocacy. So how can they help victims make informed decisions, right? So like we're kind of, like I just said, they really are focused on the well-being of that victim and the services that victim might need, the support that they need. And so they are really kind of uniquely in position to have this conversation about what participation looks like and what that participation may mean to victims and to their safety. They can talk about kind of some of those statute of limitation challenges and some of the consequences of those next level measures if it was to get to that level. So I think the importance of this cannot be minimized at all in terms of just having that extra person whose real focus is on the victim to have these kind of privileged conversations that they can answer questions. Obviously, the key here is making sure that if you can, as much as you can, you have a very trusted relationship with that service provider as well. So they're really informed as to kind of what the realities of that are.
this keeping victims informed and helping explain these trade-offs, I think it's especially a lot of these issues are going to be applicable in sexual violence cases where victims really, it's a tough decision about participating. And one of those trade-offs are not doing it now, but maybe going forward later if they can still be within the statute of limitations. But if I don't go forward now, what are the risks down the road going to be?
Right.
And I'm not saying we're not saying there's a black-white answer or something right or wrong, but giving the victim the information about how they can weigh those trade-offs best, an advocate can really help inform them and be in some degree more trusted than we are as prosecutors.
Yeah, it's, the ability to give someone the tools to give someone the ability to make kind of the most informed choice that they can and kind of understand their options. Absolutely. And so obviously we also really want to think, okay, we're talking about a victim who's been through something probably pretty horrible and pretty terrible. And how can we as prosecutors promote that victim safety, right? And to ensure that they feel like they're supported and safe throughout this process. So you want to think about things like making those appropriate arguments for bail or bond, or thinking about what conditions of pretrial release might be important, whether that's thinking about orders of protection and how that might work. But make sure you're really kind of contemplating all of that. And again, doing that with where you're getting that information is not just from the offender, from maybe past criminal history, from the actual incident, but you're also really getting a lot of information from the individual, from the victim and the survivor. And so that's another reason to really kind of have those safety planning conversations with them and discuss what their concerns are. We want to proactively investigate witness intimidation. We talked about it a little bit, but we know that, and we're going to talk about it a little bit farther along in this webinar, but you want to be really cognizant that this is probably going to happen in a lot of cases, especially if the individuals are known to each other, right? We've touched on the methods with which that may happen, but you want to really prepare with the victim and let them know, hey, this may happen and it may look like X, Y, or Z. It may look like, it may be a third party reaching out to you. It may be, and really working with your advocates to let them know also that this may be happening, and that if the victim is, assuming confidentiality and whatever the victim is okay with, but that you're being informed of this. So as a prosecutor, you can say, hey, guess what? We possibly have other charges. Possibly we have reasons why someone can have, why we might be arguing for some of these other conditions, right? So if they are violating pretrial release conditions or engaging in witness intimidation behaviors, argue for maybe revoking their release if they've been released. Argue for contempt, that they're in contempt of court. Judges, I found, are very, very unhappy when defendants don't do what they're telling them to do, right? And break those rules that the court has set. Think about possible additional charges, and then down the line, document this, because it may be evidence of consciousness of guilt and or other prior bad acts evidence that can come in at trial and can help you prove your case. And then think about regulating the discovery, right? So as we talked about, a lot of these cases, especially sexual assault cases and intimate partner sexual assault cases, privacy is a really big deal, and privacy is really important. And especially in this day and age, where we have so much digital evidence and, people's lives really can be exposed if you don't really proactively advocate to keep what can be kept private and what's not relevant private. And so a way you can do that, this is the federal rule, but a lot of state courts have similar rules where you can make a motion and show good cause, and you go in front of a judge and you say, hey, there's reason to defer discovery, so maybe just delay discovery, or in general, there's certain areas that the defendant doesn't have a right to see. They're not relevant, or whatever other possible concerns there may be. But thinking about, in most places, it's called you're seeking a protective order, right? So I think I'm going to go to the next one.
Sure. Oh, and I should note that if you don't have sample motions for protective order, if you contact us, we can help you develop that.
Absolutely. And so really what you're thinking about here are the court's really going to look at, is there a legitimate interest in delaying or denying this discovery, and how prejudicial that's going to be to the defendant. It's a really simplified way to say it. But some of the ways that we can think about protecting our victim's privacy with a protective order, a motion for a protective order, is thinking about identity, right? So thinking about the safety of the witness, or some intimidation. So can you redact identifying information? And that may be obvious, right? So names or phone numbers or addresses, but it also may be a specific piece of information that would give that person's identity away. So you want to think creatively about that. Privileged information. So a lot of times you'll get medical records or you'll have counseling records, and a lot of that may not actually be relevant to your case. Photographs during the SANE exams. So think about protecting that information as much as you can and making those orders, or making those motions for orders from the judges. If there's privacy concerns within cell phones and social media, we're going to talk about that a little bit in a minute, but think about, all of the information you're getting from someone's cell phone these days, and some of it may be completely irrelevant to your case. And so you want to really make sure that you are making those redactions and then submitting that information, those motions, to the judge for their consideration. And also thinking about, I was just going to add also, there may be ways that, judges can regulate, and regulate and kind of find this balancing act. So maybe it's that they show defense counsel can see certain evidence, but it can't go to the defendant. Or so just kind of think creatively about what those kind of measures can be in place. And then, right, so I would say most cases these days involve digital evidence, right? So when you're thinking about, it can be a wealth of information and a wealth of evidence in our cases, but we also want to be really, really thinking critically about what access we're getting to somebody's life, and how to kind of protect that. So everything that we all know that's on your cell phone, that's on someone else's cell phone, we really have to be thinking about that. Make sure you are, what are the ways in which you can kind of preserve that evidence? Can you do it with screenshots, screen recordings, as opposed to completely taking a phone or seizing an entire social media account? So think about ways in which you can get the evidence that you need without really invading that person's privacy to an extent that you don't need to. And then again, think about redacting the evidence, and inform defense counsel of those redactions and what you're redacting. In-camera reviews with judges sometimes really hate you for asking you to go through all, or asking them to go through all this, but it's their job, right? So you may be handing over a ton of evidence with your proposed redactions and saying, this is what I've redacted for the defense attorney. And that's really the way for the judge to say, yes, these redactions are correct, or no, these are not. And so I find the best way to do that, and the way you do it with protective orders. But really think about doing that. And so, we used to think about search warrants in terms of the invasion into someone's home is such an invasion into privacy, right? And now our whole lives are on our phones. Our whole lives are on this, tiny little device, right? And so the courts have been dealing with now a lot of these kind of privacy and search concerns to do with cell phones and to do with Facebook accounts and other social media accounts, email accounts. And so in Riley v. California, this case, it was a case where law enforcement conducted warrantless searches of cell phones after traffic stops. And the court held, really in this case, that no, generally searches need to be with a warrant, because there are so many interrelated privacy concerns. There's massive amounts of data, massive amounts of storage, and this information can go back in, how many years worth of information do we all have on our phones, right? So it's really and it's highly, highly personal evidence. So all of that is really important to keep in mind when you have a victim's cell phone, that you're trying to really protect all of that. And then specifically in this case, in Re BH, this is really great that a court in Minnesota upheld kind of a lot of those privacy concerns in Riley and went even a little bit farther. In this case, there was a sexual assault and the victim had gone to the police and had photographs of blood on bedding, and had some text messages and phone calls around the incident, and that was downloaded, and that part was extracted from her phone, and then the victim kept her phone. The defendant in that case then petitioned the court to have the judge order her to turn over her cell phone to the defense expert, for that defense expert to then take months and months worth of information from her phone. The trial court initially said that this was fine, and she moved to block the subpoena. And then the court in this decision said she did not have to do that. She did not have to comply, that was unreasonable. And that just by the key points are just by her bringing her phone and disclosing the sexual assault and allowing the prosecution to copy that limited portion and that brief amount of evidence, that didn't mean that she waived her right to privacy to the rest of her phone. And so the judge in that case really kind of thought about what are those privacy interests, and even explicitly stated that privacy interests in a cell phone are even greater than in a home. So really you have a lot to back up this as you are dealing with these arguments. I think a lot of times we use kind of the fishing expedition thing, right? Defense attorneys and defendants a lot of times are really just going on this fishing expedition for possible evidence that they could use to cross-examine or that may counteract what the victim is telling you. But really, there's a lot of really good case law that says that they have to have a lot more than that. They can't just go on these fishing expeditions. So we can help you out with that if that arises in your cases.
And yeah, again, I don't know if anyone here is from Minnesota, but this is pretty good persuasive authority using this BH decision to maybe persuade your own courts if a similar issue arises. If you can't get access to it because you have an affordable Lexus or Westlaw account that doesn't let you go out of state, contact us. We'll be happy to get you a copy of the decision.
Yeah. And so then we're thinking about, when you're thinking about how this may come up, right? So sometimes the victim still has the phone, right? And so then we argue that it's not in our care, custody, or control. The victim is not subject to criminal discovery. And then really victims' bill of rights can be really helpful in this. And it was something that I hadn't thought about as a prosecutor, but you can really cite to that a lot in terms of those rights to privacy, the right to be free of harassment. And again, a lot of times this comes up with defense attorneys just saying vaguely that they believe that there's evidence on a phone of X, Y, and Z, but really they have to have a very strong basis for that. Many times the phone isn't evidence. And again, just because you have that whole phone, it does not mean the entire phone is subject to discovery. Make the arguments the defense is going on a fishing expedition. And then really kind of this is where you think about those protective orders and the in-camera inspections and kind of what redactions. Just a word of caution, in some of these cases, you may think about, depending on a judge's ruling on maybe, for instance, prior bad acts evidence. In New York, we called it Molyneux. But so you may get some rulings in a case where the individuals know each other and there's that history and additional information is coming in. For instance, I once had a case where the victim had, part of our lengthy Molyneux application was that, the defendant was very controlling of who she interacted with, that she was not allowed to take classes with male professors and things of that nature. And so evidence that had been redacted and was not part of the initial discovery process then became relevant. Some of that class information became relevant. And so you may just want to make sure you're thinking about, if the judge has made a ruling, ways in which some of what you've redacted might actually then be discoverable. So just kind of a word of caution to think. Again, mistakes that were made that hopefully other people learn from. And so this is a really great kind of just if you want some case law to back up, but that Brady, which is obviously exculpatory material, which is prosecutors, we are well aware that we really need to be turning over. And I know I lost a lot of sleep over what's Brady, what's not Brady, and making sure you really are on the right side of that. But it prohibits suppression of that evidence, but it doesn't require us to act as an investigator or a valet for the defendant and gather evidence and deliver it to the opposing counsel. So obviously what you have in your possession, you have to turn over if it's exculpatory. But we don't, that just kind of is additional argument for you when a defense attorney is making a just kind of sweeping argument that there may be X, Y, and Z on your victim's phone or social media accounts or whatever.
Well, thank you, Jen. So here's where our buckets are. We talked about here are some barriers to participation, and Jen just finished talking about some strategies to hopefully mitigate these barriers to participation. Lots of strategies we can use to mitigate these barriers of participation. But when folks read the description for today's webinar and decided to join us, I bet you a lot of you wanted conversation or guidance about what to do with those tough cases where you really need the victim to testify, but the victim isn't able to testify. They aren't able to come forward. They aren't able to participate. What do we do then? How do we guide our thought process? And this is the part we really want to address now. What do we do when the victim is unable to testify? And really what this is, it goes to the essence about both the challenge of being a prosecutor and why it's so hard, because trying to weigh these risks that an offender might pose with being victim-centered and with the autonomy. And the same thing that makes our job so hard is probably what makes our job so rewarding. But these can be the kinds of decisions that keep us up at night. So before we get down to the actual mechanics, I want to sort of just start with a satellite view about a prosecutor's obligation and a prosecutor's overall obligation, which should be guiding all our decisions in all our cases, even ones where we have perfect evidence, a full confession, videotape, and everything like that. But it ultimately means doing justice and an idea of trying to make a broad view of what doing justice really is. And that doing justice as a prosecutor, part of it, sure, might be obtaining convictions and putting the bad guy away, but that's not the whole of it. And that's not the entirety of our job as prosecutors. And keeping this reality in mind about a broad idea of doing justice when we're trying to decide what to do in those cases where the victims can't participate. So really, when we talk about this really holistic idea of doing justice, go back to this Berger versus US quote from the 1930s. And I'm sure most of you prosecutors who've been to maybe prosecutor conferences, whenever they have the ethics portion, you hear this quote from Berger from, I think it was Justice Jackson who penned it in the majority decision, talking about this incredible humbling responsibility that prosecutors have and the special role as attorneys we have, because as a prosecutor, our client is not just what's happening or the government in a particular case, but it's really everyone in the community. It's the victim, it's our community as a whole and the safety. To some degree, it's even doing right by the defendant. But it's recognizing, the quote from Berger, that, hey, look, we're not an ordinary attorney where our only job is just to win the case before us to help our client. But our job as a prosecutor is to do the right thing for the right reason, to see that justice shall be done, and really to understand what does justice maybe look like in that particular case, and having a sort of wider view than just whether or not there's a conviction is what to do about it. So I'm not reading the whole quote from Berger. I'm hoping most folks really recognize it. But really it does talk about, and Justice Jackson talked about, that really our job, it's as much our duty to refrain from improper methods to produce a wrongful conviction as it is to use every legitimate means to bring about a just one. And really, there's lots of legitimate means we can do to bring justice. So what does justice look like? And this is really a case-by-case analysis, but there's lots of different things we can do to bring justice and lots of ways in which we practice, in which we have opportunities to exercise justice. This can be in the filing decision, how we decide to file charges, whether we're deciding to file charges, by taking a thorough review of documents that are produced in the case, making sure we do our due diligence, so we're not having a see no evil, hear no evil type phenomena, but we're trying to be affirmative in our duty to go forward, but also recognizing and trying to protect our obligations to victims. In our negotiations with the plea and investigating, not giving short shrift to something that really could be covering up a deeper injustice, with the cases we're bringing to trial, and also the monitoring and follow-up on cases we do after the case. But there's multiple ways to bring justice. And so I'm asking us that usually when we're confronted with the victim who doesn't want to participate or the victim who can't testify, our analysis about whether we're doing justice, it's kind of binary. Well, I need the victim to get a conviction. A conviction is how I'm going to get justice. And what I'm trying to suggest here is that when we're confronted with this circumstances challenge, when a victim isn't going to participate, that we understand our job to achieve justice. It certainly can include getting convictions, but it's not limited to just getting convictions. Sometimes a win in the case might be connecting the victim with services. Sometimes a win in the case might be, hey, look, I'm going to make sure that the next time the victim comes in, she's going to trust us or he's going to trust us, that the victim isn't going to feel like I'm the enemy, or I'm not going to give the victim a reason to feel that I'm the enemy. So the next time they need help. Some of it might be working with our community coordinated response, working with our multidisciplinary partners. So we have relationships so that even if we can't get an outcome that we might have preferred in the criminal justice system for the victim, maybe we can set them up with at least an opportunity or access to other services or lifelines for help that the victim might be able to avail themselves of someday. Other avenues as well. So essentially what we're trying to communicate here, it's a big picture of how we achieve justice. So when we're given this circumstance where the victim isn't able to testify, the victim's not going to testify, the victim is unable to participate, the real trade-off we're trying to figure out here, it's not, gee, am I going to get a conviction or lose a conviction? It's okay. If I can't go forward with this case to the degree I originally wanted or envisioned, what are the trade-offs for safety? Because one of the things I want to value to achieve justice is victim autonomy, keeping doors open for them. But I also have to recognize that if I don't have the victim available to participate, there might be trade-offs in safety. One of the questions I saw is, will we be able to receive these slides? And yes, there's going to be a copy of them afterwards. So let's talk about it. These trade-offs, these buckets about what are the risks to safety if we can't maybe fully go forward in our DV case, and to some degree our sexual violence case. But let's also talk about the risks from the victim if we don't respect autonomy too. So what are the risks to safety? And there's really the safety implications that we have to be aware of, because again, just like we're asking victims to make decisions when they're fully informed, we want to be sure as prosecutors that we're making decisions with a full appreciation of what the costs are, of what the trade-offs are. And so when we're considering, gee, if we can't go forward with this case, if we're going to have to give some sort of negotiated resolution or null pros or withdraw charges, what are the potential risks to public safety if we do that? And then we also want to weigh against that with, gee, what are the risks to victim autonomy if we do go forward? But the buckets we're talking about with risks to victim to public safety, we want to take a deeper dive in is, of course, if it's a sexual violence case, a potential crossover or serial offending. And we're going to dive into the statistics for that. Other cases, gee, if we don't hold this offender accountable, what's the future safety risk to the victim? Are we putting the victim in more danger? And for intimate partner violence cases or intimate and DV cases, if there's children that are involved, if we don't intervene, if we don't try to pursue a case, are the children in that going to be exposed to some kind of risk by continuing to be in that environment? So what are the safety implications? First of all, sexual assault cases, sex offenders, what's going to happen is it's very rare that sexual offending, sexual assault, it's usually not a one-off crime. Most sex offenders are doing this over repeated victims, and they're refining their methods of victimization. And essentially, the more an offender is unapprehended or held accountable, the more an offender is able to figure out how to refine their methods. Most sex offenses are committed by offenders who committed previous offenses. One of the ways we know this is through studies that were done with the Sexual Assault Kit Initiative, specifically from Cuyahoga County. I'm sure for those who aren't familiar with it in your own community, Cuyahoga County in Cleveland, This was a community that found a lot of untested rape kits. Well, they tested those kits, and they found out that, hey, look, a lot of these kits revealed serial offenders. Specifically with this study, which is cited here, they took just a sample of the thousands of kits that were untested. They took 243 sexual assault kits. And what they found was that about half of them were connected to offenders who committed more than one offense. And how they figured out the more than one offense is when they identified the offender in these previously untested kits, or through the DNA profile. Either those DNA profiles turned up in multiple untested kits, or the offender turned up in documented sexual offense cases that were documented. A third of those serial offenders assaulted strangers and non-strangers. So in other words, they crossed over, and sometimes those sex offenders that were serial offenders were assaulting victims that were strangers to them, and sometimes they were assaulting victims that were known to them. But what's critical about that is basically when we have an opportunity to pursue a sexual offender, it's likely that this hasn't been their first victim, that there's been multiple victims. It's not guaranteed, but this is at least a risk to safety we should be aware of and alert to. Of course, so we also have to be alert to the risk to our victims as well, especially in intimate partner violence cases. Because again, what's going to happen in most domestic violence dynamics is the danger to the victim is going to be escalating, and it's going to be co-occurring with a lot of other crimes and a lot of other offenses as well. Dr. Campbell, for those jurisdictions that use a lethality assessment protocol or a danger assessment, that's based on research. And what she found is that forced sex in an intimate partner dynamic has been found to be a lethality indicator. So in other words, if there's compelled or coerced sexual activity between intimate partners, there's a greater likelihood of lethality. A lot of our DV cases, there's going to be also encountering strangulation. That should be something that's a red alert for us. Our antenna should shoot up when we see indicators of strangulation, because that's going to be a big indicator of an escalated cycle of domestic violence. Because while not every victim of strangulation is going to be a homicide victim eventually, most domestic violence homicides have a history of strangulation. And in fact, what studies produced by some folks with the International Association of Forensic Nurses revealed that women strangled by an intimate partner are more than seven times more likely to become a victim of homicide. The other factor is too in a domestic violence cycle is while we want to do justice for the victim and do right by the victim, let me just get all this data up. We also want to recognize that, hey, look, these offenders can represent a public safety risk as well. And part of that public safety risk is the impact that a domestic violence offender can have on children in the home. And so that's going to be a factor when we're deciding what to do with the case about whether or not to go forward. What part of it is that intimate partner violence, children who observe it, they're more likely to become victims of themselves. And either this is from offenders who are going to intentionally harm them, or maybe incidentally harmed by the offender. But beyond just the physical risk to children in an environment with intimate partner violence, the exposure to intimate partner violence can cause trauma in of itself. It's essentially, it's considered an ACE, one of the adverse childhood experiences. And essentially the exposure to intimate partner violence, it causes increased developmental risk at every stage of childhood development, whether you're an infant, whether you're a toddler, a preteen, a tween, or an adolescent. And this having the exposure to this adverse childhood experience, while it doesn't resign the child, it certainly correlates with that child having increased risk for a lot of adverse life outcomes, such as health problems, mental illness, substance abuse, criminality. The other thing is exposure to that intimate partner violence for those children is going to be normalizing the violence for them as well, in a way that says, hey, look, if you're going to be a victim, it's acceptable to just take it and not look for help, that this is going to be normalizing. Or it's going to normalize it in the sense like, hey, it's okay to solve your problems with violence. So to some degree, to the degree we can use prosecutions to help resolve this situation, that's something we want to be conscious of. But again, I'm not trying to say like the only thing we're weighing are what are these safety risks if we don't go forward with prosecution? Because we also want to recognize that using next level measures on victims when the mitigating measures have failed or that they weren't sufficient, what's that going to be doing potentially to victims? Because that's going to have an impact on victims too that we have to weigh as well. Because we're not just doing this in a vacuum. There's going to be a trade-off. One, if we're imposing next level measures on victims that don't want to testify or aren't able to participate, potentially it can result in a loss of freedom. Especially if we're asking that they can't be served, courts might want to issue warrants themselves. But what can happen is potentially, especially if the victim's testimony is compelled or to come to the courtroom, that loss of freedom on a victim, someone who was victimized by an offender, can have a loss of freedom. And that loss of freedom to a victim can have a cascade effect. It might in fact impact their employment, if they're receiving education or in school, if they're incarcerated to be compelled or coerced to testify, they might not be able to go to school. If they can't take care of their kids and the offender's also in custody, what's going to happen is the children might go in care of an out of custody offender, or the children might be returned to foster care. And it could also be impacting the victim's ability to maintain custody rights over their children. Next level measures on a victim who's unable to testify, it could result in a criminal record, which could also have future impacts on their ability to get employment or gain child custody. Of course, if you put handcuffs on a victim in an effort to get him to court, that in of itself is going to be embarrassing and humiliating, especially if you book them, and you're going to be unlikely to ever get participation from that victim again, because it's going to be such an adversarial experience with the criminal justice system. And of course, compelling or coercing a victim in a case, if a victim doesn't want to testify or isn't able to testify, bringing them in through coercive measures or next level measures, there's a good chance that it may boomerang against you in the current case. It could boomerang you in the sense that the jury is going to see that you as a prosecutor are just using your power to coerce this person to come into the courtroom, and certainly make you as the prosecution a lot less sympathetic, because a jury is not going to be taking this nuanced view of personal and long-term safety risks that you might have taken. Additionally, a victim who is coerced into court, again, they might be they're probably likely going to be recanting or minimizing what happened. And you're probably not going to be in a position to pursue prosecution anyway. So that's the other reason that sort of mitigates against using a next level measure on the victim, because it's in addition to all the adverse impacts on the victim, it's probably not going to do you any good in your prosecution. I'd also note there's also the possibility you could impact federal funding that you're eligible for, depending what grants you're operating for with grant funds. And here's they have the federal citation here. But what this indicates is that in order for a prosecutor's office to be eligible to receive grant funds under Grants to Combat Violence Against Women, you'll certify that the office engages in planning and implementing protocols outlining alternative practices and procedures for material witness petitions and bench warrants consistent with best practices. So essentially, eligibility for a lot of federal grants depends on using material witness petitions and bench warrants as a last resort, and to have practices in place to avoid using that whenever possible. So failure to do that could potentially jeopardize the grant you're eligible for. So I think, Jen, oh no, I keep on going before I hand off to you. So your victim's not going to participate. You don't want to bring them into court or compel them to come into court. What can you do instead? Well, maybe one thing you can do is an evidence-based prosecution, which Jen is going to be talking about some of those strategies. Maybe the other option is going to be a negotiated plea or resolution and live to fight another day. Similarly, along those lines, maybe the decision is just going to be to withdraw charges or issue a petition for nullum prosequendum or null pros. Negotiated plea considerations, of course, try to just ask yourself like, hey, look, if the case is going south, what evidence can you get without the victim testimony that fits an available charge? In other words, you might have medical testimony proving an assault, but maybe not rape. Maybe you can pursue charges that are dependent on victim's testimony. Maybe those can be revitalized a later date within statute of limitations and without double jeopardy. And when you're considering a negotiated plea, again, taking the trade-offs about victim safety and offender risk to public safety in hand as best as you can. So I'm going to hand this over to Jen now to talk about offender-based prosecution. All of prosecutions are offender-based, evidence-based prosecutions.
Just a quick response to Jen had posted a question that I sort of answered in a very lengthy way, but also just so you know, we do have a lot of trainings that are available on our website we can talk about that are about kind of taking into account that trauma-informed investigating and kind of helping with those prosecutions. So feel free to reach out. We can work with you on that. So really, evidence-based prosecutions can be a really valuable tool if you have a victim or survivor in a case that's not able to participate. And obviously that's very difficult and usually not an option in sexual violence cases, but maybe consider some other charges that might fit if there's a different type of an assault or a witness intimidation, or kind of think about those things. And so really what's important is kind of thinking about your evidence collection and what that looks like. And a lot of this is, I think you can hit the next slide if you don't mind.
Oh, sorry.
Thank you. So a lot of this is obviously not a, entire list of everything that you can be thinking about, but make sure you are preserving those 911 calls, really kind of thinking about statements and who you can get those statements from, right? So think about preserving those statements from the victim, including, preparation for possible hearsay exceptions if you don't have that individual. Obviously considering some other legal issues, but think about, if you're a law enforcement agent or a prosecutor, you want to really be thinking about what the demeanor of the victim was or the demeanor of those witnesses were. Statements of the offender, obviously really important. And when we're thinking about statements of witnesses, think about, anybody and everybody that you may be able to get some information from. So really kind of cast a wide net in who those witnesses might be. A really thorough investigation of the crime scene is really important. What that damaged property might be, really kind of documenting through photos or video that crime scene and where the incident occurred. Think about interviewing kids on scene to the extent you're able to, and obviously documenting photos of the victim, injuries, clothing. You can kind of capture that demeanor many times in photos of the defendant. You're looking for lack of injury, right? So, a lot of times defendants will say, oh, he or she hit me first or did X, Y, and Z. And if you can document that there weren't those injuries, or some of those injuries were defensive wounds, right? So things that were inflicted by the victim. And then medical records. So a lot of times medical records can be really, really, really helpful if you ultimately have a case where the victim is unable to participate in the system. If you have those statements that were made to doctors, emergency room physicians, EMTs, and then also think about statements made to those sane and safe examiners. So the sexual assault nurse examiners. Many of them are really, really amazing witnesses at trial. And a lot of those statements made by your victim to that safe or sane examiner can come in, because a lot of times what they're saying is considered investigation for prevention of, who that person might be, might come in depending on the circumstances, and they need to know and need to kind of prepare that individual for, they might have historical injuries. They might be considering other, that history of the relationship, if it's a intimate partner violence context, is really important for that safe examiner, sane examiner, or doctor to understand, to really be able to treat that individual appropriately. And so we could talk about this ad nauseum, but really important to think about in your cases. And you can make some really great arguments that comes in. Think about your ongoing investigation. You want to keep an eye, to the extent you can, on social media accounts, or think about that for some evidentiary purposes. We've talked about consistent contact with the victim, but really making sure that you are, keeping that contact and keeping that that follow up with other friends and family and neighbors. People maybe, may change their mind about whether they're willing to speak with you, or what they might remember. And so really kind of that consistent follow-up is important. And then in terms of witness intimidation and kind of having an understanding of what's going on with your case, you really want to take a look at visitor logs and jail phone calls. Those can be a wealth of information for witness intimidation. And then when we think about preserving victim statements, you just want to keep in mind, we're thinking about present sense impressions. These are, these exceptions to hearsay, excited utterances, statements about then existing mental, emotional, physical condition, statements for purposes of medical treatment. And so we've talked about this a little bit, but these are some of the areas where that can come in. And then when we think about in terms of that opportunity for the defendant to confront the witnesses against them. So when we're thinking about that as being something that we need to show as well, you might want to think about preserving that witness testimony ahead of time. So think about if you have a preliminary hearing. And obviously you want to make sure that if you are doing a preliminary hearing where the defense counsel has that opportunity to cross-examine, it has to be meaningful. So really make sure that you're giving that discovery to the defense counsel before you do that hearing. And if you need to, give that adjournment to give them the opportunity to prepare, because you don't want them later to argue that it was not a meaningful cross-examination if you're trying to use this prior testimony. Just a note, grand jury proceedings are not going to be considered an opportunity to cross-examine, because obviously there is no defense attorney present. So, and then obviously if you have depositions, thankfully New York did not. That's just my small opinion that we didn't have to deal with that. But think about that as a way to preserve testimony as well. And then when we're thinking about when we start to talk about unavailability, obviously this is gonna differ greatly depending on your state, but generally these are kind of some overarching themes. So the state must show that the efforts to produce the witness were both reasonable and made in good faith, right? So you can't just say, oh, I asked my detective to go try and find the individual and not give them any actual information about where to be able to find that individual. But again, it all kind of ties back to this reasonableness. So what reasonable efforts did you make to find that witness? And it doesn't always have to rise to the level of a material witness order or a subpoena, but in some cases, a subpoena may be useful, which we'll talk about in a second.
So if your court does say, hey, why didn't you get a material witness petition or bench warrant, talking about these impacts, about these kinds of extra level measures on the victims that we just discussed is hopefully a good way to convince your court that would not have been reasonable for me, and because the harm it could have done to ultimately for justice.
Right. So obviously we're going to think about documenting all your contacts with the witness, document any statements by them that they are not going to appear, refuse to testify. And of course, want to obtain as many ways to contact or locate them as possible. And again, don't wait till the last minute to try and show that you have made these reasonable efforts to produce the witness. And then we have much longer, we have a lot of resources in forfeiture by wrongdoing. So this is just going to be a very brief overview, but really forfeiture by wrongdoing can really be an amazing tool to be able to prove some of these cases, especially your intimate partner domestic violence cases, in a situation where the defendant has procured the unavailability of that witness, right? So it's basically founded on this idea that someone can't benefit from their own wrongdoing. And so it's an exception to the confrontation clause. So it means that if a witness is absent by their own wrongful procurement, they can't complain if the evidence is admitted to supply the place of that which he has kept away, right? So basically it's saying you can't have the intention of someone not coming to testify and then say, oh, by the way, I didn't have a chance to confront them, right? So you forfeit that right to confront that witness. And so this is a federal rule. It's codified in the federal rules of evidence. Most states have a almost exact replica of this in their state rules. So what that means generally and very usefully is that even if it hasn't been used a bunch in your state and you don't have a lot of case law, generally you can cite to other jurisdictions or to federal case law to kind of convince your judges in situations where you want to try and argue that there's been this forfeiture by wrongdoing. So prior testimony should come in. And again, it applies to any witness who is unavailable, who the defendant has intended to be unavailable. And it opens the door to any hearsay. So that's really important, whether it's testimonial, non-testimonial. If you are able to show a judge that the defendant made that witness unavailable, then you don't have to do this confrontation clause. So the elements really are that the victim is unavailable due to the defendant's wrongdoing and that the defendant intended that result. And then that leads to admission of that victim's statements. Kind of a couple quick things is that unavailability will depend on your state, but it can even be something like real or fake memory loss. The defendant married the witness and made that person unavailable. The witness refuses to testify. And in some places, it's not even just that the defendant's intent was that, or it doesn't just have to be the defendant's intentions and the wrongdoing that made that person unavailable. For instance, there's a case where a victim also had open pending criminal cases. And so the defendant tried to argue that's why she didn't come to court. And the court said, no, that could be part of it, but it's also partly your wrongdoing. Wrongdoing doesn't have to be threats or threats of force, physical force, and they don't have to only intend that result. Their actions don't have to only be to get that individual to not testify. So for instance, in a case where a defendant marries the victim, courts have found that, well, even if part of your intention was you really wanted to marry that person, if part of your intention was to have that person be unavailable then for testimony, that's enough to show that the defendant intended it. And in cases of domestic violence, we talked about this a second ago, but in this case, the court specifically said, hey, in cases of intimate partner violence, this earlier abuse or threats of abuse are really relevant to the inquiry, right? So the court wanted to hear about prior instances between these two individuals to make that decision about what that defendant's actions then to make that person unavailable, like basically the history of their relationship and the history of those abuse, may affect the court's decision as to whether the victim was unavailable because of the defendant's actions. And there is no requirement that the defendant must engage in violence or employ threats of physical violence. So here, there may be, in many cases, it's the defendant saying, and I'm sure many of you have experience with this, but maybe the defendant saying, hi, if you don't go forward, or if you go tell the prosecutor you don't want to be part of this, like, unless you do that, we're not going to be able to continue this life, and I love you, and all of those kind of pleas towards that emotional persuasion can all go towards the wrongdoing of a defendant. So think about that. And again, this is a very brief introduction to this, but we have a lot of resources and can go into kind of a lot of the other specifics about if you are going to, if you have a case where this is something that you might want to think about, please feel free to reach out and we can talk through some of the logistics about it.
All right. So far, you're probably looking at the clock and saying, oh, wow, they're almost up on 90 minutes. They've talked about barriers to victims' participation, how to mitigate that, how to do the trade-off about whether to engage in extra level measures that we just finished talking about, alternatives to that. But what about extra level measures? And really, we designed it not to have a lot of content about extra level measures because it really is an exception to the rule. The extra level measures of material witness petitions or bench warrants, I'm not going to say you never, ever do them, but I think they really are ultimately career exceptions. The circumstances where you're going to pursue that because they can do such harm are going to be exceptional and to be done only really reluctantly. But what happens that maybe our offender is such an incredibly high public safety risk and victim safety risk where we absolutely need the victim at trial? What is our least restrictive methods about getting them to trial when they don't want to be there? Well, there's, of course, different ways we can bring the victim to court. There can be a subpoena. That's a standard way. We can ask or voluntarily request a victim to come to court. That's usually not best practice, only because there's not as much record about the victim coming to court. They might gives the victim less cover about why they're coming to court, and maybe makes it more difficult for them to get excuses to get out of work. The more extra level measures are pursuing a material witness petition or getting a bench or body warrant when they fail to appear. And these two inner things are the things we want to avoid under most, and I would say almost all circumstances. So a subpoena, the benefit of that is it's an orderly means of summoning witnesses, and it can coordinate scheduling of witnesses. When we have a subpoena, it's a good way to show our diligence to get the witness to court. It gives our witness documentation for employer or if they're in school about why they're going to be absent. And also for victims who've been pressured not to testify, having this subpoena in hand is a good way to often give that victim cover. But some of those extra level measures are going to be that maybe in exceptional circumstances we want to pursue. Might be a material witness petition. This is one of those next level measures. And these can be typically requested in advance of trial when there's reason to believe our witness is going to avoid process or not comply with a subpoena. When we're having victim-centered prosecutions, ideally, we want to try to time these material witness petitions as close as possible to the testimonial event. The reason why is because we want it to be as least disruptive to the victim as possible. We don't want them waiting in custody over a weekend or anything of that risk. And we want them to be exercised in such a way that it's not going to be in a way to embarrass or humiliate them, going to their workplace or friends or family, and really be in a way that's not victim-centered. A bench or body warrant, that's if a material witness petition is something we do beforehand, bench or body warrant is more a reactive next measure. I'm sure most folks are already familiar with it, but that's issued by the court when the witness fails to appear with a properly issued subpoena, and it authorizes the arrest of a witness so they can be brought to testify. Now, ideally, with all these next level measures, we want to mitigate the consequences for our victims as much as possible. And for reasons that are explained earlier, because we don't want all these cascading collateral consequences to impact these victims. We don't want to turn them off of the criminal justice system or make them less likely to reach out for help in the future. But part of mitigating these constant negative consequences of next level measures is, of course, recognizing them as a last resort, an exception to the rule. And when I say exception, I mean exception. I don't mean the usual practice in law where the exception ends up swallowing the rule. The rule should be is that we don't pursue these next level measures, but there may be exceptions. When we do, let's go for the least restrictive measures. Is there a way we can exercise these next level measures without incarcerating a victim? Maybe putting restrictions on travel, surrender of passport. Maybe there's going to be a pretrial services office or something like that that we could have the victim report to so we can check where they are. Ideally, avoid electronic monitoring unless that's the only alternative to confinement. Pursue these next level measures as close in time as possible to when that person's testimony is going to be needed. Obviously, try to avoid doing it on the Friday because, of course, we don't want them sitting in custody over a weekend. As I've discussed, avoid serving in ways that are going to embarrass or humiliate the victim. And when we do have confinement of our victims, avoid it occurring in places where there's going to be people convicted of crimes. The victim didn't choose to be here. The offender put him to be here. We shouldn't make it more traumatizing. We should be working to minimize re-traumatization as much as possible. Ideally, we want to implore our courts to avoid contempt findings, especially with our victims that are failed to appear, because of course that could be something that hangs around on the record and have a lot of collateral consequences. So that's really it for next level measures. And that's not really the meat of what we talked about, but I'll leave it to Jen to put it all together for us.
High bar. So I think, what we're really hoping is just that this is the beginning of a discussion and ways, really kind of challenging you to think about ways to really not only identify those barriers that we all kind of talked about and we're all very aware of, but really not just naming them, but thinking about the real world impact that those barriers are having on someone's ability to participate in the system. And then really think, how can I really support that victim participation? What are the ways in which I can work with that individual to really kind of help them be part of the system and be a participant in the system? And a lot of ways, a lot of the kind of investigative and talking about evidence and talking about evidence-based prosecutions is, like someone said in the beginning, you want to be building your case so that hopefully at least some charges or your whole case can survive without that victim participation. But you also really want to kind of support the victim with all of that other evidence you have. So if they are able to participate, it's not just balanced on the weight of their testimony, right? And then really kind of think very hard about what those public safety concerns are while you're balancing that kind of victim autonomy and really kind of thinking about what harm can be done to a victim if you do employ those kind of next level measures. And really, as John said, those should really be, something that very rarely happens in your career. And hopefully that's a very long career. It's very rarely happening in. But please, hopefully this was a good introduction to all of this. And please do fill out the evaluation that C posted in the chat if you get the chance. And again, you'll get the slides, and please feel free to reach out to discuss anything we talked about today and anything going forward that we can help you out with. I know in your work, a lot of times it's really hard to do that kind of deep dive into legal research or anything that we can help you with. We do have the time to do that. So please reach out, and thank you for being here.
Here's the contact information for your easy questions, and here it is for all the hard questions. So, but again, I thank everyone for participating and joining us today and for the work you do in your communities. C, did we forget anything?
Nope, all good.
Okay. Folks, when you get the handout, there's some appendices with just some different resources you can reach out to if you want to take a deeper dive into any of this. You can find most of this, though, by just checking out our website, but it's included here as well. But thank you. And well, Jen, I don't know what your availability is, but if folks have follow-up questions, I can hang around for a bit if you like. But
Me too.
I'll try to be one of the last people to sign off.